In this video, we are going to go over Chapter 2, the different types of evidence. In this video, I hope you will learn about identifying and classifying types of evidence, the relevance of evidence, if the evidence is admissible or inadmissible in court, the 4 types of evidence and examples of each type of evidence through real cases. So, introduction. This chapter describes how physical evidence is identified, classified, and then presented to a court of law. Physical evidence, it may be the most important factor in improving the link between the suspect and the victim. It may be essential to prove that the same suspect is linked to a series of incidents. But physical evidence is just one piece of the puzzle when investigators are trying to solve a case, but it is a very important one, especially with homicide and rape. And there's a lot of physical evidence that they could get that would be very productive and helpful towards their case. Police and prosecutors are expected to obtain physical evidence and rarely rely on confession alone because confessions aren't always reliable. And also the jury and public have come to expect physical evidence to learn about the physical evidence in the case. And then the implications of physical evidence may be confirmed by testimony of witnesses as well. So in federal court, evidence is defined by the U.S. Federal Rules of Evidence. So Article 1 says the relevancy conditioned on fact. When the relevance of evidence depends on the fulfillment of a condition of fact, the court shall admit it upon or subject to the introduction of evidence to supporting a finding or of the fulfillment of the condition, which basically means the relevancy of evidence depends on the fact and will be allowed to be shown in court if they find that the fact helps or the evidence helps explain the fact or show the fact. And then they also have relevancy and its limits. So the definition of relevant evidence means that the evidence has a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence, which means relevant evidence supports the fact that they're trying to prove in court, and it is probable or less probable. It is more probable that they will drive home the fact that they are trying to show than it would be without evidence. So the evidence helps prove the fact, then it means it's relevant. If it doesn't, then it's not relevant and it won't be in court. Relevant evidence generally admissible. Irrelevant evidence is inadmissible. So that means that all relative evidence is allowed in court, and evidence that's not relevant is not admissible. Exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, wasted time, or needless presentation of cumulative evidence. Basically, don't waste the court's time. Don't put forward evidence that can, in a way that sways people one way or another. Evidence should be factual. So relevance of evidence. Based on the results of the scientific investigation, the prosecutor decides whether the evidence will be presented in court. Whether the item is considered evidence or not is determined by the crime being investigated and the legality of its collection. If it is not legally collected, it is automatically not relevant because it can be disputed in court. Experienced investigators familiar with the case must make logical decisions about precisely which items will be examined in more detail. The more familiar investigations are with the case and the more cases they've seen, they come to a general knowledge of which items are going to be more helpful in investigations and in prosecution than others, so they want to focus their attention and tests on key pieces of evidence instead of secondary evidence that may support the key piece of evidence, but it's not as important. The judge is responsible for determining what is relevant and what is not in court. Relevant evidence is deemed admissible, which relevant or tangible evidence, physical evidence, that can prove or disprove some fact. And then irrelevant evidence is deemed inadmissible, so any item of evidence that cannot be used during trial as evidence against the accused would either, because of the way they got the evidence, if it wasn't legal or violated some rights, then it can't be used. So here's a little chart for the admissibility of evidence. If the evidence is illegal or unreasonable search admissible, it's not. If there was an independent source for the evidence, then it's admissible. If there was not an independent source, then it's inadmissible. The independent source kind of acts as a check on the evidence. They are an outside source that can verify that evidence in the testing was done correctly. Was discovery inevitable? Yes. If it's yes, it's admissible. If it's no, it's inadmissible. And did the police execute search with good faith belief that they had a valid warrant and that no warrant was required? Again, this is due to the Fourth Amendment and the search and seizure. So if you violate that, then that evidence is inadmissible. Different types of evidence. There are 4 types of evidence. Physical, which are tangible objects. Documentary, which are writing, sound, video recordings. Testimony, a witness speaking. And demonstrative, which are used to show or recreate prior events. We'll go into detail of each one. So documentary evidence, any kind of sound, video, or audio recording. Its validity is often authenticated by expert testimony. Some examples are transcripts of recorded phone calls, collected emails, bank statements, surveillance video, and contracts. So here's an example, the BTK killer. He is also known as the bind, torture, and kill killer. He was a serial killer in Wichita, Kansas, which I used to live in, between 1974 and 1991, not during that time. And he murdered 10 people over that span. This killer craved media attention and sent letters to local newspapers and TV stations, taunting investigators. He named himself the BTK killer. He wanted all the attention. When he resurfaced, so he took a little hiatus, and then after 1991, and then he resurfaced in 2004 with a series of communications that he sent on a computer floppy disk to the Wichita Eagle. Then forensic analysts traced the deleted data on the disk to a man named Dennis at the Christ Lutheran Church in Wichita. And it didn't take long for them to arrest Dennis Rader, and he confessed and was sentenced to 9 life terms in prison. So his ego got the best of him, and he sent a floppy disk, and I guess he didn't think that people could see deleted data on it, but they can't. Another evidence example, documentary evidence example, is the Lindbergh kidnapping. So in 1932, Charles Lindbergh Jr., the 20-month-old son of a famous aviator, was kidnapped. They wanted a $50,000 ransom, which was paid, but the child was never returned, and his body was discovered months later, just a few miles from his home. They tracked the circulation of the bills. So the bills themselves, they have the serial number on them. They're used in that were used in the ransom payment. And then authorities were led to Bruno Hauptmann, who was found with over $14,000 of the money in his garage. While Hauptmann claimed that the money belonged to his friend, key testimony from handwriting and analysis matched his writing to that on the ransom notes. Additional forensic research connected the wood in his attic to the wood he used as a makeshift ladder to kidnap the child. And then he was convicted and executed in 1936. So the second kind of evidence is demonstrative evidence. Basically, it's on the principle that a picture is worth 1,000 words. A physical illustration of the facts presented rather than a verbal description. It's meant to clarify, explain, and offer a visual aspect of the presentation. It helps jurors understand the evidence better. Most people are more engaged and remember visual presentations than fact. And over on the side, you can see that an example of documentary or demonstrative evidence where they outline the timeline of this victim. It looks like, just by looking at it, that it was an abuse case, and they can document when they sustained these injuries to show a pattern of abuse. And again, I see that just by looking at it instead of hearing like an hour of testimony about it. When you're given a lot of dates, you tend to forget them easily. So demonstrative evidence, like a timeline, is very helpful. And then examples are cardboard model of the crime scene. I don't think they do cardboard anymore. I'm sure they have better technology. Photographs, video animations, like the one on the bottom. Diagrams, charts, x-rays. And then some I've seen, they have a huge glass jar filled with medications to show the thousands of pills a plaintiff must take due to an injury. Or if they say, the toxicology report says that they have X amount of this medication in their system, they'll fill a glass jar and be like, this is how many pills they would have had to take to have this concentration in there. The third type is testimony. So evidence in the form of witnesses speaking under oath in court. There are different examples. So an eyewitness is a person who has personally seen some act, occurrence, or object and can give a first-hand description account of it. Hearsay witnesses, statements made out of court from a witness under oath, offered in court to prove the truth of the matter asserted, can be oral or written. There are many different reasons why the witness does not go into court to give their testimony. So they are allowed to do oral or written testimony under oath. And then there are character witnesses, which are people who attest to another's moral conduct and good reputation in the court of law. They can testify on behalf of another as to that person's positive or negative character traits and the person's reputation in the community. So character witnesses can either help someone or hurt someone. They speak to how they are, that they know their reputation and how they see them. And they're most often used in criminal cases. So for example, character witness in the Larry Eiler case. He was an American serial killer who is believed to have murdered a minimum of 21 teenage boys and young men between 1982 and 1984. In sentencing hearings, so after he was already convicted of the crimes, they do sentencing hearings to see what their sentence should be. Sometimes in state where they have the death penalty, the sentencing hearing will see if they deserve life in prison or if their acts justify execution. Larry Eiler's mother, stepfather, sister, and Catholic chaplain all testified to the kindness and decency they had observed in Eiler's character. So these are character witnesses. A janitor named Al Burdicki, testified to having witnessed Eiler make between 8 to 12 trips to his communal storage locker. Eiler lived in an apartment building. On August 20th, with Eiler saying he was just getting tools for a job. Hours later, Burdicki witnessed Eiler making 3 separate trips to the garbage receptacle. So this is an example of an eyewitness. He saw these things going on with his firsthand knowledge. So what had happened was Eiler murdered a boy in his apartment after torturing him, I'm sure with different tools, and then dismembered him using tools, including a saw, and then threw away the body parts into garbage cans. So he had to take 3 separate trips to the garbage can to throw away all the different parts of the body. So this is a slide from a previous video. So the 4th evidence, and it's the most important and the one that you will deal with the most in forensic science, is physical evidence, which are tangible objects that are real and not circumstantial. So trace evidence found at the crime scene, property recovered at the crime scene after it's been committed, like fingerprints, tire tracks, shoe prints, handwriting, or as a crime has been committed. So it's property recovered as a crime has been committed. Sorry, my little video is covering up the word, which are fingerprints, tire tracks, shoe prints, handwriting, as examples. And then weapons used to commit a crime are physical evidence. So an overview of the type of evidence. An example is a murder for hire trial. This is not a real one, this is a hypothetical one, but I'm sure you can find one that's kind of like this. They tend to leave a paper trail and get caught fairly easily. So during this trial, the prosecution introduces the gun used in the crime or bought for the crime, photographs of the crime scene. So if they actually successfully murdered the person, then the gun used in the crime, the photographs of the crime scene, the contract calling for a murder in exchange for money. The contract has been signed by the defendant, and a witness identifies the defendant as the one who shot the victim. So this shows all 4 different types of evidence. The gun is physical evidence. The contract is documentary evidence. The photographs are demonstrative evidence. So the thing about photographs, you can have photographs of the crime scene that help show different parts of the crime scene, but then you can have photographs as documentary evidence to show things that lead up to it. So if it was murder for hire and a wife wanted to hire someone to kill her husband, and there's a photograph that shows the crime scene where the husband is the victim, which is demonstrative. But if it was photographs that showed the husband with a mistress, then those are documentary and they go towards the motive, not painting a picture of the crime scene. And then witnesses, the witness that identified the defendant is testimony. So I hope you learned in this video that federal courts define the relevancy of a piece of evidence. Admissible equals relevant, inadmissible equals irrelevant and not presented in court. There are 4 types of evidence: physical, which are tangible objects, real objects; documentary, written, audio, video evidence; demonstrative, which is evidence used to demonstrate facts through pictures, demonstrate facts of or to put the physical evidence in perspective for people; testimony, statements under oath. Another thing about the demonstrative evidence is really great when you have an expert witness testifying and they talk in science mumbo jumbo that the jurors not all jurors would understand. So having a graphic or something that they can look at while the expert witness is talking, then that helps them a lot to understand what the expert is trying to tell them. That is